Hello and welcome to the online presentation of the Village of Streamwood's Crime-Free Housing Initiative training. My name is Commander Darrell Sari and I'm here to guide you through the training. It is important that you not rush through the training and you try to absorb all the material being presented to you. In order to demonstrate your successful completion of the training presentation, you are going to be required to complete a quiz that covers the material discussed. You must get all of the answers correct on this quiz in order to receive a certificate of training, and this certificate will be proof that you completed the training and should be brought with you when obtaining your rental license or licenses. While this training is mandatory in order to receive a rental license, its sole focus is to help you, the landlord. The information we provide you today may help prevent major tenant issues in the future. This training will direct you to services for background checks. It will provide you with a lease addendum example which will allow you to take action against a problem tenant if that situation arises. This program will tell you a little bit about the background of the program and why it is being implemented now. We will share helpful tips on how to reduce criminal activity on your property, which is intended to save you lots of trouble down the line. Why crime-free? I am sure some of you have heard about the broken window theory, the theory that one small piece of disorder, like a broken window, will allow for more serious disorder if left unchecked. By not addressing the smallest of issues, we send a signal to the community that it is not worth taking care of. Therefore, paying attention to these smaller nuisance type issues is important. Crime isn't just a problem for the police. Crime is a community problem. Crime takes place in a community. It is most often perpetuated by other community members, and everyone in the community has a stake in finding a solution. Landlords have powers that police departments do not, especially when it comes to criminal tenants. Landlords are involved in a civil relationship with their tenants, which police cannot be involved in. Landlords are the gatekeepers to the community. They help to decide who lives in the community and can help to prevent their property from becoming a problem property for the community. It is the intent of the village's crime-free housing initiative to reduce criminal and nuisance activity within the village. We hope to improve the engagement of landlords with their property and tenants in an effort to improve the overall management of that property. We are not looking to fine or punish anyone. We want compliance and overall positive experience with the landlords and their tenants. It is a goal of this program to prevent problem tenants from establishing a foothold in your properties, but also gives you the tools necessary to deal with a problem tenant should the need arise. We would like a positive experience for everybody in every community. The ordinance is not meant to benefit or privilege any group of people over others. We are not trying to keep anybody out of Streamwood except those who wish to do harm here. The village of Streamwood is currently divided into 4 distinct boundaries that we call beats. Each beat has a beat sergeant and a beat commander assigned to address any immediate and/or chronic concerns. Residents are encouraged to attend monthly beat meetings which are scheduled to occur at the police department and usually run from spring through fall. You are also encouraged to attend these meetings for the beats in which you have property. All of the information concerning these beats can be found under the Services tab for police on the village's website. Police resources are not limitless. It is impossible for the police to be patrolling every street at all times, and the resources we do have can be tied up quickly in an emergency situation. With this training, we are trying to prevent what some in law enforcement refer to as the balloon effect. The balloon effect refers to police resources having to be concentrated on a specific part of town to deal with chronic problems, and while those problems are being addressed in that area, the problems simply move to another part of town, like air in a balloon being squeezed from one area of the balloon to another. The police are very good at short-term fixes like making arrests when someone commits a crime. But once that person is released from custody, they go right back to their home or your property. It is important to understand the difference between civil and criminal law. Criminal law is a body of rules and statutes that defines conduct prohibited by the government because it threatens and harms public safety and welfare, and that establishes punishment to be imposed for the commission of such acts. Civil law is a body of rules that delineates private rights and remedies and governs disputes between individuals in such areas as contracts, property, and family law. Your relationship with your tenant is governed by civil law, not criminal law. Civil law requires only a preponderance of evidence, which means that you must be more sure than unsure that a violation of your contract has occurred. The police department's main strength is dealing with criminal issues. If you have a problem tenant that is committing criminal acts, the police can't arrest that person. This arrest is not a guarantee that the person will not be back on your property, causing more problems for you in the neighborhood. If your renter is able to post bond on their case, they will certainly be back. However, if a landlord has a preponderance of evidence that criminal activity is occurring on their property, the landlord is able to begin civil proceedings to evict the tenant if they choose not to cease that activity. It was mentioned earlier in the presentation that landlords are the gatekeepers to the community. This is true in this sense. The police cannot keep track of every person who moves into their town and even into their rental properties. But you as landlords do have the ability to know of and screen all adult persons who wish to reside on your property. Then even after they have moved in, you should have a relationship which allows you to determine if they are good renters and neighbors. The crime-free program is not asking you to do the job of the police. It is asking you to be involved in your property in such a way that you are working as part of the community to help curb crime. In this next section, we are going to discuss 3 steps you can take in order to help reduce the potential for crime occurring on your property. These steps are tenant selection, active management, and property maintenance. The first step to reducing the potential for crime is to avoid renting to someone who will have a negative effect on your property and the community. The process of choosing a tenant begins with the application. It is extremely important to have as comprehensive an application process as possible. Make sure to obtain consent to conduct background criminal history checks on all adults who will be residing on your property, as well as a financial check on the person or persons responsible to pay the rent. You want to have clear and established criteria for acceptance of their application, and you need to apply the same standard to every tenant without exception. To do otherwise can open you up to civil problems. Be clear with the prospective tenant about your expectations. Make sure they are clear about what you consider acceptable behavior, as well as what you consider unacceptable behavior that could void their lease. The goal is to deter anyone who plans on using your property for illegal behavior and encourage them to move on. At a minimum, your application should ask for the following personal information from all prospective residents age 18 or older. You should ask prospective tenants for the full name, to include their middle initial, their date of birth, their social security number, current phone numbers to include cell phone number, their driver's license or state identification number. You will also want a copy of each. You should ask for their current address to include their current landlord contact information if applicable, previous address information, employment information, emergency contact information, vehicle information, and their criminal history. You can also ask for the name of any residents who are under the age of 18. The following are examples of questions that you may not ask on an application, and they cannot factor into your decision on whether to rent to a person or not. These are protected class questions, and they include race, color, national origin, religion, sex, familial status to include children under the age of 18 living with parents or legal guardians, pregnant women, and people securing custody of children under the age of 18, and disability. Here is an example of an acceptance policy taken from the website biggerpockets.com. This is a simple example, but notice how it still specifies a minimum credit score and minimum income. You want to make sure that the language used in your criteria is clear and concise, and that the standards are specific. It is also advisable that you maintain a standard to conduct a criminal background check. It is important to be upfront and clear about your acceptance criteria when speaking with a prospective tenant. If you are mailing someone an application, be sure to include a copy of your acceptance policy. However you distribute your rental application, make sure an acceptance policy is attached. Doing so will help to demonstrate you are acting in a systematic and non-discriminatory manner. As mentioned earlier, it will also help deter applicants who know they will not qualify from attempting the application process. This will save you valuable time and maybe even some money. Meeting with a prospective tenant face-to-face during the application process is an extremely helpful criterion and is highly recommended. A convenient time to do this would be during a site visit designed to show the property to the prospective tenant and to show the prospective tenant to you. You can have a series of questions to ask the prospective tenant in an effort to gauge their credibility, or you could decide to go over their application answers during this time. Doing this offers you a good opportunity to address any questions or concerns you may have about some or all of their answers. Although you should not reject someone for feeling wrong, you can use their behavior during this face-to-face meeting to factor in how it relates to your acceptance criterion. Lastly, if someone needs assistance with the application process, help them. This can be confusing to some people, and you do not want to lose a good tenant because they did not understand something that you could have explained. Criminal background checks, like your application, should be thorough. It is recommended that background checks are conducted on all adults who would reside on your property, and you should have clear criteria in place for what is and is not acceptable in order to obtain the lease. Be systematic. Carefully consider what requirements you want to set regarding criminal background checks and apply them equally to every prospective tenant without exception. While you cannot control what each individual company report contains, you can control what you ask for and thus what is provided to the background check company. I can tell you that the more information you ask for on an application, the better your chances of receiving a more comprehensive and accurate report. You must also recognize that the background check services are not perfect and they may contain flaws. It is also possible that the report received is very accurate, but your prospective tenant does not agree with it for some reason. If a prospective tenant does not meet your criteria and they claim the information you used to come to the conclusion is false, you can provide them with the name of the service used for them to address the issue with that service. I would let the prospective tenant know that you cannot accept them based on the finding, but offer them the option to reapply if the issue gets resolved. Do not use a service that accepts or rejects prospective tenants automatically. You need to do this yourself based on the report received, but remember to remain consistent to all applicants. Another tool you have at your disposal for checking a person's background is your local police departments. It is recommended that you complete a Freedom of Information Act form at the police department where your prospective tenant currently resides and ask for any reports related to the address where the person resides, as well as any reports related with the name of the applicant. You may also go one step further and ask for reports related by name to any additional adults that may be residing in your property. It is up to you how far back you want the police department to pull records from, but I would start with at least the past 2 years' worth of activity. You can always ask for more if need be, and remember to apply the same criteria to all prospective tenants. Lastly, you need to understand that a person can be arrested and charged with a felony, but it gets pled down to a misdemeanor in court. It is recommended that you not only consider whether a person has been arrested for a felony or misdemeanor, but also the number and frequency of arrests. If a person has multiple arrests, and some of them are recent, you need to consider whether that is something that is acceptable to you. You may also want to consider that a person has multiple arrests, but the last one occurred many, many years ago. You could conclude that the person was locked up for all those years, or they have changed their behavior for the better. Here is an example criminal background report from Tenant Verification Services. Notice at the top where it notes the subject is on the South Carolina Sex Offender Registry. If the subject was to object to this reference, you would be able to go to the registry and match his face with that of the identification he provided and or your personal observation of him. This report also lists identifying features of the subject of the report in case there is a different person named Joe Tenney who may be the actual sex offender. Not all background check services are going to be the you may have different costs and may provide different information. You You will be provided some service companies to examine in a future slide, or you may have one that you are happy with already. I can tell you that they are all going to be as effective as you allow them to be. If you give them minimal information because your application does not ask for a lot from the applicants, you are going to get a minimal report. The more information you can provide to them about the subject of the report, the better. The last of the 3 steps I want to discuss is the financial background check. As you created acceptance standards for the criminal background checks, you should also establish acceptance standards for the financial checks. The example criteria shown before listed a minimum credit score. This is a good idea. Decide what criteria you believe best for your property and apply the criteria to all applicants. Avoid services that accept or reject an applicant automatically. You need to have your own criteria to fall back on if you are challenged by an applicant. The industry standard is that rent must not be more than 30% of an applicant's income. You should confirm the income source listed by the applicant by checking the source. Some background check services will do this for you. You should also call their previous landlords to see if they report any issues or would recommend you not rent to that person. Again, it is important to understand that even financial checks can have errors. One study of financial check reports found that 79% contains some sort of error. An error can be something small and insignificant or something very significant. An error can work to benefit an applicant or hurt an applicant. The thing you can control is how you deal with the report you do receive. Our suggestion is to reject those applicants who do not meet your established criteria, tell them why you are not accepting them, and give them the information for the company that conducted the check in case they are able to provide information that changes the result. Above all, be consistent. Here are just some example sources for companies that conduct background checks for property owners. We are not endorsing any particular service. Use a company that suits your needs.
Hi everyone, my name is Karen Nelson. I'm a licensed clinical social worker employed by the Village of Streamwood and based in the police department. I'm here today to briefly mention the importance of expectations and communication with your prospective renters. As a homeowner who's beginning the rental licensing process, I feel it's really important to keep in mind your future tenant's previous living environment. For example, you might have a tenant interested in your single-family home that's lived their entire lives in the city and not had the responsibilities that come along with maintaining a larger property. From handling maintenance issues and yard work, be clear from the very beginning about what your expectations of them are as tenants, what their responsibilities may or may not be, and how those might be divided between yourself and the renter are keys to a successful landlord-tenant relationship. Thank you.
The second step to crime prevention on your property is active management. Being a landlord and renting to tenants is a big commitment. If you have been a landlord for any amount of time, you know this, and if you are new to the idea of being a landlord, you will learn this. Some tenants will test the resolve of their landlords more than others, and some will be extremely easy to work with. The important thing to realize about this relationship is that you have the ability to control which of the 2 scenarios your landlord-tenant relationship will be. It starts with tenant screening and continues to evolve with active management. A good way to maintain an active presence on your property is through regular or scheduled property visits. Checking the upkeep of the outside as well as the lighting can be a good reason to stop by. Ensuring the smoke detectors and fire extinguishers are in working order are good reasons to stop by. You may also determine that you or a representative collects the rent in person. This would give you a regularly scheduled monthly visit to the property. While at the property, you should be looking for anything that may cause concern, like the upkeep or cleanliness of the property. Remember to address the small concerns before they become large concerns. Make sure to always provide your tenant notice of your intention to stop by and do not be invasive. This is a good time to look around for anything out of the ordinary or to address maintenance issues, but nothing gives you the right to go digging through their personal effects. If you become aware of criminal activity occurring at the residence, you need to report it to the police department. Do not attempt to address it yourself. Active management is a good tool to keep those that are inclined to criminal activity from renting your property. If someone inclined to criminal activity believes you will never show up to the property and engage with them, they will feel more inclined to engage in illegal acts on your property. It is true that rental properties are at particular risk of this occurring, not because renters are more prone to crime, but because people who are inclined to engage in illegal activity are happy to live in a place that they can vacate without any penalty or consequence if things turn bad for them. A 1998 study showed that drug dealers chose rental properties they thought had a weak management presence over a strong and active management. Active management may seem like a lot of work, but having a problem or criminal tenant residing on your property because of a lack of active management would be much more troublesome. The following slides contain images from the Community Development Department. You will notice homes in extreme disrepair and disarray. These problems did not occur overnight, and these photos represent some of what an active management program is designed to prevent. You cannot be at your property every minute of every day, so managing your property from afar has its limitations. Promoting a certain level of ownership in your tenant can go a long way to ensuring your tenant takes care of the property you both have a stake in. Allowing the tenant to customize and personalize the property in an acceptable manner can have a positive effect on the tenant's desire to maintain the property. Remember the video from social worker Karen Nelson in which she described the previous living environments of prospective tenants? How some of them may have never lived in a home where they had to cut the grass or trim the bushes. You may find it necessary or desirable to provide your tenants with the tools, such as a lawnmower or vacuum cleaner, to help them maintain the property appropriately. Additionally, you want to set the example. If you expect them to maintain the property you own, they will expect you to make the repairs that are needed to maintain the property you own. Doing so in a timely manner will demonstrate that you care about the condition of the home and will help to ensure they do the same. This may save you time and money in the long run. It is never too late to make the changes necessary to promote positive change in yourself and the tenant. The following slide contains a video of Officer Tom Sparks providing an example of positive change to an apartment complex in Streamwood. The complex was known to the police department as an area where crime and drugs was rampant. This was in part due to a management company that only cared about receiving the rent payments each month. Because the complex was riddled with criminals and drug activity, the people renting were not only few, they did not really care if they paid the rent. A lot of them decided to remain on the property free of charge until they were evicted. Needless to say, the owners of the complex decided there needed to be a change. A new management company was hired, and with the changes made, the complex is no longer the hotbed for criminal activity it once was. I do believe the complex has more tenants, and these tenants are paying their rent.
Good afternoon, Officer Tom Sparks, Streamwood Police Officer. I'm here today to talk about one of our properties in town that I want to say recently has gone through a dramatic change. I want to say back in 2008 when I was one of the street officers here and was routinely assigned to this area of town, we experienced a large amount of calls for service, which includes everything from vagrancy complaints to criminal damage to property, graffiti, and not shortly thereafter we experienced a huge drop in calls, and being assigned to that area was somewhat inquisitive and actually spoke with the person on scene that was the management person for the building. What they explained to me is they did a large change in their way they actually allowed applicants into the facility, and one of the things that they did is they ran a background check and actually required some type of credit score. I'm sure they must have had a number in mind, because once they initiated that policy or procedure, it didn't take long for us on the law enforcement side to see a huge change in the calls for service. And to take it one step further, that actual management agency went ahead and took some proactive crime prevention steps as well, improving lighting, removing bushes that, you know, kind of created a natural habitat for people to kind of hang out in. They changed simple things like closers and locks on doors so that people couldn't easily prop them open. There was a camera system I know that they made sure was up and running that eventually actually kind of did not need in the long run. A prime example would be comparing, say, 2008 statistics up until last year, and the difference is huge. We're talking 230 calls for service. Again, everything from, you know, ambulance assist, criminal damage to property, to you name it. So not all of them are criminal related. However, if I told you in 2014 we only had 36 calls for service, the benefit there, just not in law enforcement, but seeing the community change in its entirety in that building, you know, is light years difference. I couldn't begin to tell you the difference in, you know, safety. I'm sure the people must feel there, not having to worry about having, you know, their cars being, I don't want to say ransacked, but just having the criminal element hanging out there all hours of the night. They've done a huge step to try and allow the people that are in there that are of meeting their requirements staying there, and it's kind of propagated itself to having an entire community there that's, you know, at least on law enforcement standpoint, has been able to almost self-sufficient. The maintenance there, you know, will call us to document the graffiti, but they are the ones that actually remove the graffiti, and it's that day, if not an hour later after we're done documenting it, to make sure those things are covered up, and the people living there obviously continue their existence without having to see a lot of those things. So it's kind of an all-encompassing perspective, everything from the application process all the way through to the maintenance of the building has made, you know, a huge difference. And, you know, one prime example, you know, if there was something as crime-free housing, would stand as a perfect example, in my opinion, and having worked it and seen the difference from beginning to now, I would consider the end. I mean, I don't know how you could, I don't want to say do something better than that change. If you asked me today, what more could they do, and short of adding landscaping and walkways would be very difficult. I doubt there would be any crime-related recommendations we could make as a police department. It's just been that dramatic of a change.
The third step in reducing crime on your property involves making your property an environment that is inhospitable to crime. This is known as crime prevention through environmental design, or CPTED for short. The benefits of maintaining the physical space of your property are many. A cleaner, more attractive property should attract more conscientious tenants who are less prone to criminal activity. A little investment on the front end should pay dividends in the long run. Besides the obvious benefits of a properly maintained property attracting better clientele, CPTED is a thought process of maintaining a property to make it less attractive to outside criminal elements. For instance, if you have a subject casing a neighborhood for homes or vehicles that look easy to burglarize, that subject is more prone to look for a home that is poorly maintained as a target. That subject is more prone to look for a home that has trees and bushes so overgrown that it will shield him from the neighbors as he breaks into the home or automobiles. The subject will look for a home that has little or no lighting to illuminate the outside during the evening hours as well. It is important to think about these things as a burglar might think about them. You obviously can't prepare for every eventuality, but you should prepare for those that you can. You should make sure to cut the vegetation from around the home so that it is not blocking windows or the line of sight to the street. Make sure that you have appropriate lighting and that it is functioning properly at all times. You may find it helpful and cost-effective to put the outside lighting on a timer or install motion-activated lights. It may also be beneficial to remind your tenants to close their windows at night or when they are away in order to minimize the likelihood that someone targets the property. Providing your tenant with strike plate secured doors, locks on windows, and something as simple as a dowel to place in the track of a patio slider are inexpensive and effective means of minimizing risks. You can conduct an internet search for crime prevention through environmental design and obtain lots of helpful information. The next two slides give you a before and after example of what CPTED can be. They are followed by a video of Village Attorney Tom Bastian speaking about the eviction process.
Hello, my name is Thomas Bastian. I'm one of the village attorneys for the village of Streamwood, and as part of the Crime-Free Housing Initiative program, I'd like to take a few minutes to discuss with you the method of evicting a tenant who's violated provisions of the lease, whether it be non-payment of rent or violating any other material provision of the lease, including but not limited to the crime-free lease addendum. In Illinois, a property owner, property manager, or landlord can only evict or dispossess a tenant under the provisions of what's called the Illinois Forcible Entry and Detainer Act. That is the sole method for dispossessing a tenant and suing for possession of the property. A tenant can be evicted for violations of, as I said, any material violation of the lease, including but not limited to violations of the crime-free lease addendum. Those violations, material violations, could be damage to the property, loud noise, parties, failure to abide by conditions such as no pets. There are two types of action under the Forcible Entry and Detainer Act. One for possession only and one for possession and rent. Each action requires a different type of notice. For an eviction other than unpaid rentals, the landlord must serve the tenant with a 10-day notice to quit. For violations of non-payment of rent, even if that includes other violations of the lease, the tenant must be served with a 5-day notice of termination of tenancy. Under both circumstances, the notice must be personally served or served by certified mail, return receipt requested. If the notice is just posted on the door or shoved under the door, the tenant may have an argument, and a strong argument, that he or she was not properly served. In addition, the person serving the notice of termination of tenancy, and it doesn't have to be the landlord or property owner or property manager, anyone can serve that notice, but they must also sign a proof of service attesting to the fact that they were served. The ideal situation is to serve the tenant himself. However, anyone residing on the premises over the age of 13 years can be served, but I suggest a follow-up notice be sent regular mail to the tenant. Now, if the action is for possession only without rent because of non-rental violations, you must serve the tenant with a 10-day notice to quit. No other notice is required. If the action is for rentals, you serve, as I said earlier, a 5-day notice of termination of tenancy. If the tenant pays the overdue rentals in full within that 5-day period, you may not proceed with your eviction action. But again, only full payment of all rentals due and owing are acceptable. If you take part of it, you may still proceed with the action. The process to evict the tenant is relatively simple. In your packet of materials, you have a sample complaint for possession and a sample complaint for rent and possession, or a sample complaint for possession only based upon a non-monetary breach. Please review the complaint form and fill it out exactly as the sample shows. It's very important that you include the landlord's name as the plaintiff. The defendants are the tenants on the lease, but in addition, you must now also include, after the name of the tenants, unknown occupants. When the complaint is properly filled out and signed, you will take the complaint along with the summons. There is a summons included in your packet. You will take that to the Rolling Meadows Courthouse, located at 2121 Euclid Avenue, Rolling Meadows, Illinois, and that's in the 3rd Municipal District. The Village of Streamwood is in the 3rd Municipal District, and that is the proper venue for the eviction court. You will give the one original and 3 copies to the clerk of the court, and that is located in room 121 on the 1st floor of the Rolling Meadows Courthouse. The clerk will stamp the copies and the original. The clerk will keep the original. You will also give copies and an original summons, which the clerk will stamp. You will pay your filing fee at the clerk's office, and the clerk will direct you across the hall to the Cook County Sheriff for purposes of service. There is a filing fee for service of process also. You will give all of that to the sheriff. Now keep in mind, as far as a return date for the court date, that will be supplied by the clerk's office. When you give the complaint and a copy of the summons to the sheriff, they will take the complaint and summons and attempt to serve the defendants. You can check with the sheriff's office as to whether or not the defendants or the tenants were served. If they were served, you will go to the designated courtroom in Rolling Meadows. It will be either room 205 or 206 on the 2nd floor of the courthouse on the date and the time that is listed on the complaint and summons for hearing. Now, forcible detainer actions, eviction actions, are what's called summary proceedings. In almost all circumstances, the court will proceed on that date. If the sheriff was unable to effect service, you will still have to go to the court on that date, and the sheriff will ask if there is a proof of service, a return of service. If there is not, you will ask the court for a new date to issue what's called an alias summons. And you have to repeat the process. File the alias summons, fill it out, file it with the sheriff. They will again attempt to serve the tenants or defendants. In the event you cannot serve the tenants, you have 2 options. One is to hire a special process server, which can be quite costly. And the longer the tenant is in the property, especially if the reason for the eviction is non-payment of rent, the more money it's costing you in terms of lost rentals. You have an option by service by publication, and the court clerk can assist you with that process. In service by publication, it will be posted or listed in the paper. It will also, 3 copies will be posted in the surrounding community. What that does, on the next return date, you will show the court the proof of service by publication, and if your complaint is in order, and of course you must explain to the court what the breach was. They haven't paid rent. Here's my 5-day notice. 5 days elapsed and they still haven't paid. The court will enter a judgment for possession only. When service by publication is made, you cannot get a money judgment, only possession of the property. But in my experience, if a tenant is 3 or 4 months behind in rent, and they are avoiding service, chances are, if you get a money judgment, you're not going to be able to collect that anyway. So what is most important is you get possession of your property so that it can be put back on the market so that you can get a new tenant or tenants and start earning, receiving the rentals that you may need to pay the mortgage if there is a mortgage on the property. If the sheriff was able to serve the tenants, and they do appear, the court will ask the basis for the eviction. You will, again, tender the court the 5-day notice of termination if it's for non-payment of rent. The court will inquire of the defendant, have you paid the rent? No, why not? The court may also ask if the two of you have reached any agreements in terms of the rental payments. And if the answer is no, you will ask the court for an order of possession. You will also ask the court, and you must have proof or some proof that the tenant hasn't paid. For example, if the tenant has always paid by checks, you're going to keep a ledger of the checks were received on this date, this date, and this date, but after October 1st, I've received no more payments. If the court grants you a money judgment, you will include that in the court's order. Now, there is a specific order of possession that the clerk of the circuit court and the county uses. That order will be filled out. The order will say a judgment is in favor of the plaintiff, the landlord, and possession is granted. However, oftentimes, for example, if it's in the middle of the month, the court will stay its order, meaning it's not enforceable until the end of the particular month. When you fill out your order of possession, the court will sign it. The court may also certify that order. On the date possession is to take place, and not before, you must, and unfortunately this is kind of a laborious process, you must take that order of possession to the Daily Center, to the sheriff's office at the Daily Center, pay an additional filing fee to lodge that order of possession with the sheriff of Cook County. I believe the sheriff's office is on the 6th or 7th floor of the Daily Center. You will file your order of possession with the sheriff, and the sheriff will log it in, and they will place it with, frankly, all of the other orders of possession. Your order of possession is good for a period of 90 days. If the sheriff is unable to serve the order and evict the tenant within 90 days, you will have to have that order recertified by the circuit court in Rolling Meadows, the same place where you presented your eviction complaint. If the sheriff is able to serve it, or it's near at the top of the list to be served, the sheriff's office will notify you, and you must be present at the premises on the day the tenant is evicted. If the sheriff dispossesses the tenant and they try to go back into the property, they can be charged criminally for trespass to land. Now, assuming everything goes smoothly, get your order of possession, and the court enters the money judgment in your favor, you must seek to enforce the money judgment, whether that be by a citation to discover assets or a non-wage property garnishment. But again, it's been my experience that many tenants who have defaulted on payments of the rent, on their rent are somewhat judgment-proof. They don't have the money to pay the judgment. If they are working, you can only deduct 15% of their weekly wages, subject to minimums and maximums. And if there is any person ahead of you in line with a wage deduction, you must wait till that is satisfied. Likewise, on a non-wage garnishment relating to property, they may not have a bank account if they can't afford to pay the rent. Now again, one thing that's very important is when you file your complaint, it must include, in addition to the tenant's names, unknown occupants. Finally, it's very important that you as a landlord protect your interest in your property. And one of the best ways of doing that is to make sure you do a criminal background check and a credit check on the potential tenant. It's going to cost you a little money up front, but it helps to weed out those persons that are not tenant worthy because they have a history of not paying rents, other bills, or they have serious criminal history. The money is spent up front may save you a lot in the long run at the end. It really does help you select good quality tenants that will respect you as the landlord. And it is a two-way street. You have to work with your tenants and they will respect the property and you will have a good landlord-tenant relationship. Thank you.
In the final part of this program, I am going to talk to you about 3 of the local ordinances you need to be concerned with as a landlord. These ordinances are the Rental Licensing Ordinance, Nuisance Abatement Ordinance, and the Crime-Free Initiative Ordinance. All 3 of these ordinances can be found on the village website. To rent property in the village, you must be licensed by the village. The following slide contains a video of a community development employee explaining the rental licensing process.
Hello, I am Matt. I am a code enforcement officer and I'm here to talk to you a little bit about the rental licensing program. A rental licensing program is required by all residents that are not owner-occupied. The way the licensing works is it's a calendar year license, so you're required to get one every year. They expire on December 31st each year. You can start renewing licenses as of November 1st of each year. They are $150 and that's an annual fee. After December 31st, however, the fee increases to $200 and every 30 days that fee will increase. Each rental unit gets inspected every year. An inspector comes out every year and they will look for several things. Mostly we're looking for your plumbing, your electrical. We'll check your water heater, your furnace. Some common problems are smoke alarms. We will check each smoke alarm, make sure the batteries are working and that they are up to date. We'll check for carbon monoxide detectors, for placement as well. Windows have to have screens, no tears in screens, and we'll look overall aesthetics of each property, so property maintenance, stuff outside, grass is a big deal. Other than that, that's about it.
The second ordinance you should be familiar with is the Nuisance Abatement Ordinance. This ordinance is enacted when those in a property commit certain nuisance type activities. This includes the commission of many Class A misdemeanor offenses, any felony offense, and or 3 or more separate violations of the Village Property Maintenance Code. The ordinance does not include the offense of domestic violence or related domestic issues. Incidents of a domestic nature are handled in a different manner and have the best interest of the domestic violence victim in mind. The Nuisance Abatement Ordinance applies to every residence in the village, whether it is owned or rented. The purpose of the Nuisance Abatement Ordinance is to address those properties that have repeated or chronic issues. It is possible that after a property has had at least 3 nuisance occurrences within a 12-month period that you and your tenant are notified of the violations by letter. This letter will notify you that your property is now in Phase 1 of the nuisance abatement process. If your property receives at least 1 more violation within a 12-month period of being placed on Phase 1, your property can be placed into Phase 2 of the program, and you may be asked to meet with the Chief of Police and his designee to establish an abatement plan to curb the negative behavior occurring at your property. If you should receive another violation within a 12-month period of being placed on Phase 2 of the nuisance abatement program, your property may be considered a nuisance property, and you and your renter can be ticketed for each additional occurrence, and the fine for each occurrence can be up to $750. These tickets would then be set before a local administrative court for review. The intent of this ordinance is to increase the quality of life for the residents of Streamwood and keep them free of chronic nuisance properties that can plague an entire neighborhood. The crime-free lease addendum that you must institute as part of your rental program is another tool designed to assist you in handling nuisance tenants. It defines what activities you deem nuisance activities and lease violations and allows you to act to evict if they violate the lease. Make this very clear to all prospective lessees during the application process. The last ordinance is the reason you are doing this training. It is our hope that the crime-free housing program will help to improve the quality of life for the residents of Streamwood, as well as enhance the relationship between landlord and tenant. As part of the continuing educational process, you will be required to complete a bridge recertification training after you have completed this initial training. The ordinance currently states that you will be required to perform a bridge recertification in the third year of a 4-year cycle and a full certification every 4th year. Currently, all trainings will be conducted at the police department on a once-monthly basis, but they may also be completed online. The certificate of completion for these trainings should accompany your rental licensing application when you renew each year. This ordinance is about establishing relationships between you, your renters, and the village. It is important that you understand we want an open flow of information, and we encourage the reporting of anything criminal or suspicious that may be happening on or near your property. It is our hope that this training provides you with some insight and screening for more trouble-free tenants, and the potential for problems is reduced. Finally, I want to close with some words of advice from Leigh Robinson, a longtime Chicago landlord and author of Landlording, a handy manual for scrupulous landlords and landladies who do it themselves. Leigh says avoiding an eviction essentially involves dealing with tenants face-to-face, meaning you need to be involved on your property and stay in contact with your tenant if you want them to be successful on your property. He also advises you to supply detailed instructions about filling out the rental applications. This should make the process less painful for applicants and help you get the information you want on the application. Leigh also recommends creating a personalized scoring system for applicants. This kind of system will help you compare applicants in a fair way that will be easy to fall back on if challenged. This completes your online training. Thank you for participating.